We will go on the record in the matter 24 CF13, State of Wisconsin versus Gerald Lindquist. The state appears through District Attorney Kevin Schmidt in person. We have Mr. Lindquist in person in custody with counsel Gregory Alman. We're set here today in this matter for a plea and sentencing. We are in victims' rights compliance, Ms. Bauer.
Yes, Your Honor.
I do have victim appearing by video conferencing capability. We're set today for the plea and sentencing. The parties reached an agreement, I believe, at the other hearing, and it was recited on the record. However, Mr. Alman, can you please recite the agreement for the record for today's purposes?
I can, Your Honor. Thank you. Mr. Lindquist will plead no contest to count one burglary. Date of alleged event is September 21, 2024. Count two will be dismissed and restitution will be determined.
All right. Thank you. Briefly adjourned. I'm not getting any writing. I will get out and see if I need to do it again. Not getting this. Oh, now I see hello. Okay. Back, what? That's all I see is hello. 5 times, 4 times.
The rest is there.
Okay, well, I don't need it. I just like it sometimes. Okay, back on the record, same appearances as previously noted. We have heard the offer. Victims' rights are in compliance. Mr. Lindquist, I have in front of me a plea questionnaire waiver of rights form. Do you recognize the document?
Yes.
Did your attorney go over this document with you?
Yes.
Did he go over it thoroughly with you, essentially word for word?
Yes.
And you understand everything on that document?
Yes, I do.
Is that your signature on the second page?
Yes.
Attached to the document are the jury instructions for burglary with intent to steal. Did your attorney thoroughly go over those with you?
Yes.
And so he also went over the maximum possible penalties you face?
Yes.
You are pleading no contest to burglary, a class F felony.
Yes.
You are 60 years old. It looks like 10 years of schooling,
Yes.
and you can read, write, you understand the English language?
Yes.
No drugs, alcohol, or other medications, or mental illnesses or disorders?
No.
Because you're charged with crimes, you are entitled to constitutional rights, and each of those rights is listed on that first page. Did your attorney thoroughly go over those rights with you?
Yes.
Do you understand them completely?
Yes.
Do you need me to go over those rights with you in any more detail?
No, I don't.
Do you need me to read these rights to you out loud?
No.
Do you understand that by pleading guilty, you're waiving and giving up those rights?
Yes.
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
Right. Yes.
Do you understand that you're pleading guilty to a felony? As such, you will no longer be able to use or possess a firearm for life.
Yes.
You will no longer be able to vote in any election until your civil rights are restored.
Yes.
All right, so you're pleading guilty here to the burglary.
No contest, Judge.
Oh, sorry, no contest. And that's due to potential other civil ramifications and the fact that he believes that the state could prove it beyond a reasonable doubt, even if he doesn't believe all of the facts that are alleged.
He's not admitting guilt, Your Honor, but he does admit that there's sufficient facts that if a jury believed by a jury could result in a finding of guilt.
And that's accurate and true, Mr. Lindquist?
Yes.
Okay, so you're pleading no contest to the burglary, a class F felony. Now, here, the state would have to prove as to that count 1 on or around September 21st, 2024, in Burnett County, Wisconsin, you intentionally entered a dwelling owned by KMF without the consent of the person in lawful possession of that place and with the intent to steal items of value. That is a class F felony. Do you understand what the state would have to prove? $25,000 or imprisonment of up to 12 and a half months or 12 years and 6 months or both. Do you understand that?
Yes.
Do you also understand that there is an agreement that's been reached between the parties where the court will order a pre-sentence investigation report and it's free to argue? Do you understand what that report is?
Yes,
And do you understand the contents of that report?
yes,
And do you understand that you'll be able to provide insight to the agent for the report?
yes,
And do you understand that report will have a recommendation as to sentencing?
yes,
Do you understand the court is not bound to follow that recommendation?
yes,
And the court is not bound to follow any recommendation or argument by the state of Wisconsin.
yes,
And the court is not bound to follow any argument or recommendation from the defense.
yes,
Do you understand that the court is free in its own discretion to sentence you to what it believes is an appropriate sentence, which could be all the way up to that maximum possible penalty? You understand that?
yes,
Did you go over the criminal complaint with your attorney?
yes,
In particular, there's that section called the probable cause section where it basically says what happened that day and why you were charged with the crimes. Do you remember that?
yes,
For the most part, as it relates to what you're pleading no contest to, and what you believe a jury would find to be true and accurate, for the most part, are those facts accurate?
yes,
Mr. Almond, may the court use the probable cause section of the criminal complaint to find a factual basis?
Yes,
So you're pleading no contest to this charge, Mr. Lindquist. You may have a differing opinion as to some of the facts and or the crimes you committed, but for the most part, you understand and went over the information with your attorney that if this were to go to a jury trial, you would be found guilty, correct?
yes,
All right. Has anyone made any threats or any promises to you for you to plead guilty to the charge?
no, I haven't.
You're doing so freely and intelligently. That means you're telling the court you fully understand what you're doing
Yes,
and voluntarily.
yes,
Has your attorney represented you competently?
no,
Has he done a good job?
okay, yes,
And he's looked at the case
yes,
and he's looked at the facts
yes,
and he's looked at the discovery and the evidence in the case.
yes,
And has he discussed that with you?
yes,
And you've discussed the facts from your perspective with your attorney?
yes,
And has your attorney discussed with you a potential for any legal defenses or a lack of defenses in this case?
no,
Has he went over and said, if you go to a
No.
jury trial, we could argue this as a defense?
yeah,
And then he said, well, based upon my analysis, there is or is not a defense?
yeah,
And have you discussed with him what you believe in your capacity to be any defense or a lack of defense?
yeah,
And have you talked with him about any other witnesses or alibis or co-defendants that you may know to exist?
no, I mean. there
Can you
was
talk
no-
to him about this whole case?
Yeah,
And if there were people with you, did you let him know who they were?
yes,
And so you've told him everything that you know as it relates to this case from your perspective?
yes,
Are you satisfied with his services?
yes,
Mr. Almond, do you believe Mr. Lindquist is entering his plea freely, intelligently, and voluntarily?
yes, Your Honor.
Do you believe he fully understands the facts that the state would have to prove to find guilt beyond a reasonable doubt?
I do believe so, Judge. He seems to.
Do you believe he understands both the strengths and the weaknesses of this case?
Yes, I do.
And he's competent to enter a plea today?
Yes, as far as I can tell.
And he understands the rights he's giving up?
Pretty smart guy. I think he does.
All right. Mr. Lindquist, do you have any questions for the court or for your attorney before we proceed?
not at this moment.
All right. Then at this time, as to count one, burglary of a building or a dwelling, a class F felony, how do you wish to plead?
No contest.
The court will find that your plea of no contest is done freely, intelligently, and voluntarily with a full understanding of the facts of the case, as well as the rights that you're giving up here today. I'm going to find a factual basis. I believe you understand the charges and the maximum penalties. So I will enter judgment against you. You're pleading no contest, but that is essentially the court is finding you guilty of the matter. Judgment of conviction is entered today. The other count is dismissed and read in for purposes of sentencing. The court will order a pre-sentence investigation report. Long form. Agent does not need to appear but should be readily arise. Bond is hereby revoked. We need to set sentencing. Anything the state wants to add before we get a sentencing date?
Is that, I think we might want to consider 90 minutes because I assume we'll be doing the restitution hearing at the same time.
All right. Mr. Alman, anything you want to add?
I wasn't anticipating a restitution hearing at the same time, Judge, but if that's what we want to do. I'll have to get my experts lined up to do that, to deal with it.
If you need more time after sentencing,
I'd prefer to do it another time if the court will allow.
I don't see a problem. Any objection?
No, and if he has experts, I wasn't intending to rush anybody with it.
Yeah, I just wanted to see what's in the PSI, and then we'll see what kind of an issue we have or don't have.
All right, that makes sense. And Ms. Bauer, talked to the victim about their input on having it the sentencing day or anytime thereafter, if they have any feelings about it whatsoever. Yes, Your Honor. I can do July 15th at 9. And I can go until 11, just in case we have victims making a statement.
I can't that morning, Judge.
Could you that afternoon?
I could.
I could start at 1.
I think a little later by chance.
I could start at 2 and we could go the rest of the day if we need to.
Sure.
Okay, 2 o'clock on July 15th. Anything further from either side at this time?
Not from the state.
No, Your Honor. Thank you.
All right, then we are adjourned. Thank you. Thank you, victim. We are going to adjourn and then go on to our other case.
As soon as I have the PSI, I'll come see you.
All right.
All right, we will go on the record in the matter 25 CF 174, 26 CF 49, State of Wisconsin versus Dennis Young. The state appears through Assistant District Attorney Jose Vila in person. We have Joel Feliski, Defense Counsel, in person with Mr. Young. We're set today for a status and an initial appearance in the new matter. Mr. Feliski, were you able to go over the new criminal complaint with Mr. Young?
Thank you, Your Honor. I was able to review the complaint with Mr. Young. I believe he understands the charges here and the maximum possible penalties. We'll waive formal reading to counts 2 and 3, enter in pleas of not guilty, and for count 1 would request a preliminary hearing outside of time limits.
Just give me a second. I'm going to look at commissioners. I think I'm going to throw in a prelim if he wants one. Because my calendar is pretty full in the summer. Do June 4th at 2:45.
That will work.
All right, June 4th at 2:45 with Krupa. All right, anything further?
Not at this time, Your Honor. Thank
All
you.
right, thank you. Then we are adjourned.